This is case number 22-195-334. This is Absolute Resolution Investments LLC versus Coleman Hall. The matter is before the court, set on for a pretrial scheduling and status conference. The court is in receipt of the defendant's answer regarding this matter and is aware that the claim asserted in this matter alleges damages in the amount of $5,324.61. Your appearance for plaintiff in this matter, please. Absolute Resolutions, are we all mute?
Good morning, Your Honor. Michael Bankstein, P69778 on behalf of Absolute Resolutions.
All right, thank you, and good morning to you, Mr. Bankstein. I'm looking now for Coleman Hall. Last name is Hall. If you're on the Zoom, please say something at this time.
I'm not seeing him here. I don't, unless he's in the courtroom. I'm not seeing him on any of the Zoom panels here.
Yeah, neither am I. Have you had any contact with Mr. Hall during the pendency of this matter?
Yes, we've had some. Hang on one second. I don't want to speak out of turn without double checking the notes. It looks like we have made several attempts to call defendant, and defendant has called our office before, so we have had contact. I'm not seeing him here today, though. I mean, basically, if he's not here today, I'd like to move for a default judgment, Your Honor, under the 7-day rule.
All right. So, in those efforts to contact, were there any efforts to reach out to try to get the case resolved on Mr. Hall's part? Is that what you did?
Yeah, I do see an inbound call from the debtor when we were talking about possibly settling. It doesn't appear that it came to fruition, though.
Got it. All right. Very well. So given the fact that the court did generate a notice regarding this matter, that notice did go out to Mr. Hall at the address that he provided on Bishop Street. That address was provided in his at the filing of the case, and also in his answer to the complaint. So the court is convinced that that is an accurate address. The time of this hearing was set forth. One of the concerns that I had was that, of course, the notice went out with 534, and this Zoom is 336. But Mr. Bankstein, you were able to find this location. I think there was a redirector, so that would have been available to Mr. Hall as well. I'll grant your petition for entry of default at this time on the defendant's failure to appear in this matter, and I'll sign an order consistent therewith upon his presentment. You may present your order to the email address that's at carmen.banks, first name Carmen, C-A-R-M-E-N.
I'm sorry, that happened real fast. I got C-A-R-M-E-N, but then it kind of shattered.
That's right. That's you got the first part right. That's Carmen dot, last name is Banks, B-A-N-K-S. That's at 36th 36 District Court.org.
Thank you, Your Honor. Did you want us to submit the default judgment under the 7-day rule?
Yeah, I would. In this particular case, I would suggest that you do it that way, given that there was some effort to reach out, and perhaps the defendant will that will come to fruition and maybe get resolved. Go ahead and submit it under 7 days. That would be great. Thank you, counsel.
Thank you, Your Honor. Have a great day.
Likewise. The court now calls case number 06161532. This is Asset Acceptance LLC versus Demetia Harris. It appears the matter is before the court on the following objections to a writ of garnishment. That garnishment relates to Compass Group USA. The record should further reflect regarding this matter that a judgment was entered in this case. Looks like that judgment was entered on the 3rd of April 2017. The judgment is $3,842.24. Looking at the objections, the petitioner indicates that there is a bankruptcy proceeding, that the writ was not properly issued or is otherwise invalid. Your appearance for asset acceptance, please.
Your Honor, William Hill, P 28608, appearing on behalf of Asset Acceptance. I have Tremesia Harris on one of the cases. The original plaintiff I have on this was Asset Acceptance. Are we on the right file?
Yeah, we're on the right file. That's the one I'm looking at this point.
Okay, thank you.
I have Tremesia Harris. Ms. Harris, if you're here, say something at this time. Harris, first name is Tremesia, last name is Harris, a person living on Butte Street. If you are on this Zoom, please say something.
She is here. She's currently muted. She spoke earlier to the clerk.
All right. Ms. Harris, thank you, Counsel. Ms. Harris, if you'll hit *6 or tap your microphone, it will get you off the mute, ma'am.
Okay, yes, I'm here.
All right. Good morning to you, Ms. Harris.
Good morning.
I've looked at your objections to the writ of garnishment. You said that you filed bankruptcy. What's going on, man? Talk to me.
I just recently got this notice. I didn't know anything about it. It came through my job, and the writ was not properly issued. I didn't know anything about them. I've been at my residence for 12 years. I never received anything from them about a garnishment, about any of this. I don't even know what this is about. They sent a DTE bill.
Okay, well,
And-
let me stop you, because you didn't answer my question. You filed this and you said you filed bankruptcy. What are you talking about?
No, when I went down there, because this is my first time ever going through something like this, I said,
Let me stop you. Let me stop you. I need you to answer a basic question for me, and we'll get to the other stuff. But you have
Okay.
one here. You have one here that you have a bankruptcy petition. Is there a bankruptcy on this?
No, it's not.
Okay, well, let's get past that. Then you said it was not properly issued. Man, there was a judgment entered against you back in 2017. So I can't go back and deal with any of that. That's what this filing is based on. It's based upon that judgment that was entered against you. And that judgment was entered. Let me just look at it for a moment here. It does relate to a DTE bill. And the documents herein indicate that this case was served on you by a court officer back in 2000 and looks like 2007. Yeah, 2007 on Carlisle Street, the same address that you're using now. And then the judgment was initially entered back in 2016 or 2007. And then it was renewed in 2017. So it's been going on for a while now. This is a renewed judgment.
That's the thing. I don't even know nothing about a Carlisle Street. I don't understand what is this coming from. That's what I'm saying. Nothing was never gave to me.
All right. So
I know nothing.
All right.
That's what I was trying to tell them. I don't know nothing about a Carlisle Street. I never lived on a Carlisle Street.
All right, ma'am. So what you're gonna have to do, it seems to me, is that you're gonna have to file something with the court trying to get that judgment set aside now some 11 or 12 years later. You can file a motion or a petition to try and get the judgment set aside. There is, in fact, a judgment against you now. The court will now allow me to address those issues, to allow me to address any underlying issues such as the judgment. The only thing I can address today is the fact that you do have a judgment and that there is a garnishment against you. We can deal with that part, but I can't address the underlying issue that you're raising, where you're saying that this is not you, should not have been filed against you. You have to file a motion requesting a hearing on those issues. Right now, what you have is the judgment against you. Let me hear from the other side. I'll come back to you, Mr. Hill.
Yeah, yes, Your Honor. Just to refresh the defendant's recollection, this was a 3-count complaint. 2 of the accounts were DTE, okay, and the other one was SBC Michigan. The judgment was entered in 07. In April, it was renewed in April 2017. And again, this is the objections to a garnishment are improper at this time. The defendant seems to be attacking the underlying judgment itself. I'd ask that it be denied and the funds be released.
All right, so So yeah, man, I mean, that's kind of the history of this, and I'm certainly concerned, but because you're indicating that you're not aware of a BTE bill, that you didn't have a bill in your name anywhere on Carlisle Street, or let's see, let me see what I can see in the file. Just one moment. Yeah, I have a couple of affidavits indicating that there was an account or a couple of accounts that resulted in this debt that has occurred before the court. And then that's already been decided by a judge on a previous date back in 2006, and they renewed again in 2017. Moreover, it looks like, just one moment as I take a look here. It looks like in 2021, there was a writ of garnishment filed against income taxes. Looks like over the years that there have been various garnishments that have been filed with the tax unit of the state of Michigan. Let's see what else is going on.
I don't know nothing about that. Income taxes. What was they taking my state taxes? I just don't know nothing about it. Okay, and then you saying something about SBC, phone bill. I don't even, when was these things even sent to my address? Do they have an original bill? Do they even have an original bill? I don't even know anything about these bills. I have DTE now. Why would they allow me to get DTE again if I owe this money?
You know, for what it's worth, we're showing that there were garnishments successfully obtained back on April 9th, 2015 of $294. Presumably that was a tax garnishment. Okay, I'm also showing a garnishment of April 21st, 2014 of $95. That may have been a wage garnishment. Our file is reflecting. We're also showing that the defendant resides on Promenade.
I don't live on no Promenade.
Okay. We're showing that was the address that we have in our file. Again, if this is a motion to set aside the judgment, the objections to garnishment are improper. If she has a valid defense and meritorious defense and good cause, we can address that at another hearing.
Yeah.
Yes, I live on. I'm sorry, Judge. I'm sorry.
Let me stop you. Let me stop. All that don't mean anything. I don't care where you live and all of that. The problem here is that, and it's not that I don't care about you. I don't care about any of that. The issue that you have is that you have what's called pre-judgment and post-judgment. The issues that you're raising are issues that are pre-judgment issues. You're saying that the judgment should have never been issued. You can't raise that issue right now in front of me. You have to file a separate motion to do that. The only issue that you can bring in front of me now is that the judgment is somehow, that the garnishment is somehow invalid because you, number one, already paid the judgment because there's a bankruptcy or you're already under some kind of payment plan. And none of those things exist. So you don't have a valid defense to the garnishment. You may have a valid defense to this case, but you have to file a motion to set the judgment aside, explaining why you have not responded before now, and put that in writing on the second floor, and explaining the defense that you have, indicating that this is not your debt or something. You have to file that, and then the court will give you a hearing on that to determine whether or not that judgment should be set aside. If the judgment is set aside,
how do I file it?
Well,
how do I file it?
I can't be a lawyer, but I think there are a couple of things that you've heard from me already. One is that you filed your paperwork on the second floor in this building. You probably need to file what's called a motion to set aside the default judgment. And on the documents that you make sure you explain what happened, explain why you didn't answer, and explain what you would have answered if you had received the documents. Because there's a file here that shows a lot of stuff. So you're gonna have to explain, and that might help you to get it set aside. It's been 15 years or so. So you got an uphill battle. In fact, what has it been? 17 years since this has been going on. So you got an uphill battle to try to address that part. But you can address it in that way. And if you address it in that way, then a judge has to take a look at it and decide whether or not the judgment should be set aside. If the judgment is set aside, then all of this goes away. If the judgment is set aside, all of this goes away. But if it's not set aside, then that means that you have to deal with payment issues of payment. So as it relates to the writ of garnishment, this is your wages. Is that correct? This is where you work?
Yes.
All right. And how much money is being taken from you on a, what do you get, paid every other week?
Yes, every other week, $300 and something,
Okay.
something that I cannot afford for something that's 17 or 18 years old that
Yeah.
ooh.
I'm not going to give you an opportunity to try to address this issue if you keep interrupting me. I didn't ask you about those things. Obviously, even if you could afford it, you don't want people taking your money. I'm explaining to you why that's happening. And maybe there's something we can do at this point while you decide whether or not you want to file your motion to try to address this issue. So that
Yes.
it looks like they're taking about $700 from you a month under the garnishment. So, ma'am, what I will do in this situation is that first of all, any money that's withheld is going to be released to the plaintiff. Then what I'm going to do is I'm going to set it up for you to pay $200 a month so that you can get from up under the garnishment. What happens is if you're able to get this judgment set aside, any money that you pay, you will be able to get all of your money back. On the other hand, if for some reason you're not able to get it set aside, at least you'll have something in place so that you don't get that garnishment of all a month. That's the best that I can do with this today. I am concerned about your situation because you described this as something you don't know anything about. But we have to start where we are, and that is that there's a judgment, and you can file paperwork indicated to you to try to get that set aside. And I don't know if you'll be successful or not, but that's where you have to start at. So what I'm going to do, I'll find the objections invalid. I'll release funds withheld to the plaintiff. I will suspend the garnishment, and that's just suspending it. It could be put back in place, but I'll suspend it as long as you make payments of $200 a month while this case is pending. So that first payment, ma'am, is going to be January the 27th. So you'll want to make a payment to the address that is on the documents that you got, asset acceptance, the attorney's name is there, and you want to make a payment there by the 27th of January. I'm going to send you an order that you take to your payroll department, and the payroll department will stop taking money out of your check when they see the order that I issue. And then you have to voluntarily make on the 27th of January. Now, in the meantime, you can file whatever motion you want to file, and we'll take a look at it. And if it gets set aside, you get your money back and the case gets dismissed. If it's not set aside, then you have to go forward and continue making the payments to try to get this resolved. You understand?
Yes.
All right, I know that's not the greatest and best outcome, but that's where you have to start it now. You'll get a couple of orders from me in the next couple of days. Take it to your payroll department, and they'll stop garnishing, and then you'll be able to make your voluntary payment. Right? I do wish you well, ma'am. All the best to you. Thank you, counsel. Good day to you.
Thank you.
Thank you.
You will,
Him and his wife are there?
yes, they
You
will
could
come
take
in,
this to the
okay,
courtroom.
sure, okay,
I
I just want,
appreciate
you're welcome.
Okay. All right, this is case number 07143371. This is Asset Acceptance LLC versus Deborah Thomas. The matter is before the court on objections to a writ of garnishment as it relates to the third-party withholding unit of the state of Michigan. This case arises by virtue of the fact that a judgment was entered in this matter on the 10th of January 2008. That judgment was renewed at a subsequent time. Looks like that was August the 28th of 2017. The judgment upon entry was $993.59. All right, your appearance for asset acceptance, please.
Morning, Your Honor. William Hill, P 28608, appearing as coverage counsel for asset acceptance today.
All right, thank you, and good morning to you, counsel. I'm now looking for Ms. Thomas. Deborah Thomas, if you're on the Zoom, please say something at this time. Ms. Thomas, Deborah Thomas. All right, counsel, have you had any?
She's here, Your Honor, but she's muted. I see her on the screen.
Yeah, she's there, Judge, next to him.
Oh, yeah.
She's muted though.
Yeah, I couldn't see her because I'm looking everywhere else, but next to Ms. All right, Ms. Thomas, are you able to hear me, ma'am? Shake your head, nod your head if you're able to hear me, Ms. Thomas. Good morning, Ms. Thomas.
Ms. Thomas,
Ms.
wait.
Thomas? Ms. Thomas? Good morning. Let me send a chat to her and we'll get right back to you, Council. Member Clerk, we'll get a second to send the chat. Oh, no, that's all right. You're busy. Do what you do.
I got it.
What'd you say?
Who I'm sending it to?
Ms. Thomas. Deborah Thomas, tell her that her case is up. Go ahead. All right, Mr. Gill, I'm coming right back to you. My clerk is going to reach out to Ms. Thomas by way of a chat.
Okay, thanks.
All right, the court now calls case number 15-113735. This is Public Service Credit Union versus Charles Arrington Jr. The matter is before the court on the filing of objections to a writ of garnishment. This is regarding Navy Federal Credit Union. The record should reflect regarding this matter that a judgment was entered in this case. Looks like the judgment amount was $11,372.25. I'm looking at a parent entry date in 2015. Looks like 10/26/2015. The objections indicate that it's not properly issued or is otherwise invalid. There's a claim of identity theft in regard to this matter. Your appearance for Public Service Credit Union, please.
Yes, good morning, Your Honor. Stephen DeLuca on behalf of the Plaintiff Public Service Credit Union. My P number is P70009.
All right, thank you, counsel, and good morning to you, sir. I'm looking now for Charles Arrington Jr. If you're on the Zoom, please say something at this time.
Good morning, sir. Good morning.
Oh, yeah, I see you there. Thank you, Mr. Arrington, and good morning to you as well. All right, so this case has been going on since 2015. You said that this has something to do with identity theft?
Yes, sir, Your Honor. Yes, sir. I do apologize for interrupting you. I have approached Public Service Credit Union several times. I have 2 police reports. The first one was is the first number that which I've entered, which was entered 2014 when my identity was first stolen, and apparently it's gone on. And I've contacted the credit union, which was there's no resolve there. I was improperly served by the law firm because what they did was they entered an address on documents and sent it into the court.
Let me stop you with regard to the service issues. You'd have to file a different type of motion to address that. All right.
Okay.
Your principal issue that you are raising here is that this is invalid because of the because you filed an identity theft affidavit and you put them on notice that your assets or your property stolen, that someone defrauded you, correct?
Yes, sir.
All right, let me hear from Mr. DeLuca, sir.
Yes, thank you, Your Honor. This is an objection to a bank garnishment. First, I'll say that the objections are moot because we received a disclosure from Navy Federal Credit Union indicating that there's no funds in the account to withhold. So based on that alone, the objections are moot and should be denied. To the extent that the court considers the objections further, the defendant is essentially attacking the underlying judgment, which, as the court knows, is not permitted under MCR 3.101K. This is not the proceeding to do that in. Defendant would need to file a separate motion to attack the underlying judgment. So based on those reasons, the objection should be denied. I'll also state, though, it may be helpful the defendant to turn on his camera. We can't see his face. We do have pictures of him in the credit union branch at the time that he took out this loan. So that would be helpful for me to know who I'm dealing with. But I think the objection should be denied. If the defendant wants to file a motion to set aside the judgment, he's free to do that, and we can respond accordingly.
All right, so Mr. Arrington, there are no funds in the account, correct, sir?
Yes, sir.
All right.
Correct.
Now, the issue then will be a moot issue as it relates to the objection to the writ of garnishment. That's the only issue that's in front of me. To the extent that you would like to get that judgment set aside based upon identity theft type issues, you would raise that by filing some type of motion and presenting those issues before the court for consideration. At this point, there is in fact a judgment, and when you file your motion, if you choose to do that, you can also raise issues regarding whether or not service was proper, et cetera. I would indicate to you that given the fact that that this has gone on for some time, and that there have been other garnishments that have been attempted, that likely on the issue of service and what have you, then you probably don't have anything to work with there, because you receive notified over and over again regarding the fact that there is a judgment. But identity theft is a significant issue, and to the extent that you're able to establish that that may have been a predicate, and you provide a good reason as to why you didn't respond previously, that may be something that will give you some ways of trying to attack the underlying judgment. Today, given the fact that there are no funds in the account, that issue would be moot. The objections would otherwise be invalid, and the court is going to sign an order consistent therewith. You'll get a copy of that order. Again, this case does not address your underlying issue, because you have to bring that property by filing the proper paperwork to do so. The final thing I'll say is that Mr. Luca indicated that that they have photographs of someone that took that received the money from the credit union. And
They received money?
Someone received money from a public service credit union, and that's what this case is all about. And Mr. DeLuca says that they have a photograph of that person, and he'd like to see you, and if it doesn't match that photograph, that's the end of this case. If you want to do that, I can put the two of you in a breakout room and you can figure that out.
I'd be happy to talk to Mr. Arrington about that. I'd be happy to share that photograph with him. I can give him my contact information.
All right.
That's fine.
So why don't I put the two of you in a breakout scenario so that you can address those kind of issues. And if you get anywhere, then you get somewhere. If not, then of course the judgment is still outstanding in this case. So
Well, I would prefer to file my motions because I'm at work, and if I can, I believe on the writ there's contact information, and if he works with these the Holzman law, I can give them guys a call.
That sounds fine.
Well, whatever you want to do. They tell me in geometry the quickest way between 2 points is a straight line. So
Yes, sir.
You know, if you talk through it, if the photograph is not you, you probably got the end of the case. But if you own that photograph, you know how that is. That's
Right.
not the end. All right. So I wish you well. You do have a notification if the two of you want to go in a breakout room. If you don't, then a good day. I'm ruled on the case. You'll get a copy of my order shortly.
Okay, thank you.
Okay, thanks, Your Honor. Happy New Year. Have a good one.
All right. Was that the record regarding the suffix 3371? That's Asset Acceptance LLC versus Deborah Thomas. Counsel, I noted your appearance regarding this matter. I'm trying to reach Ms. Deborah Thomas. Ms. Thomas, are you able to hear me at this time? Ms. Thomas, did Ms. Thomas respond to your text?
She's still muted. She may have her microphones turned off.
Yeah, it seems that there is something going on along those lines. Just one moment. I don't think so.
You have host. You should be able to click on her in the corner where that blue icon is.
Yeah.
Do it, ask her to unmute. She's reading something.
Oh, no, she just saw my notation. Ms. Thomas, I've been trying to reach you. Can you hear me? Ms. Thomas, you need to turn up your microphone, ma'am. Turn up your speakers.
Are you talking to Aisha, a Galaxy 12?
No, nope, I know you'd like for me to be talking to you. I'm talking to Ms. Thomas.
She's off mute now, Judge.
I know, but she must have her speakers turned down.
Oh,
Ms. Say something to me. Talk to me. Ms. Thomas? All right, we're not getting anywhere. Ms. Thomas. All right, so let's see if I can work through what is going on here. Hopefully, Ms. Thomas can hear me. She indicates in her petition that the funds are exempt, and she did provide to the court a document indicating that she receives Social Security assets, and that is her source of income. Of course, Social Security funds would in fact be exempt. Counsel, anything you have to say in this regard, sir?
Yes, Your Honor, I'm somewhat troubled by this one. We received her pleadings, okay, and we can see that this is her sole source of income. Social Security would normally be exempt from any garnishment. However, plaintiff emailed me last night a case that I was unfamiliar with, Asset Acceptance versus Hughes, 268 Mich. App 57. I pulled that case out of curiosity, and it turns out that homestead property tax credits are not exempt. I don't understand the reasoning in it. There was a wonderful dissent by Judge Karen Ford Hood on this case. However, this appears to be the law. The case has not been attacked.
Yeah, I know we get a little bit of Yeah, that case has been out there for a bit, and it's a troubling case. It talks about in a sense, the changing of the nature of the Social Security funds by virtue of the homestead exemption that allows for money to be recycled, if you will. Yeah, it's been there for a moment. I think it works a substantial hardship on persons that are Social Security recipients. And but you're right that it has not been contested. There has not been any appeal from that particular decision. I don't know how it applies and if it applies in this particular case. That is my concern here, and I can't let us get to Ms. Thomas this morning.
I'm assuming that the garnishment would go to the homestead property tax credit, and she would normally receive some money from the state of Michigan. And we're going to concede that her sole source of income is Social Security. Personally, I don't agree with the decision, but I'm kind of bound by it on behalf of my client in this case. I'm going to leave this one to the court's discretion.
Yeah, given that what I've received, and I've dealt with this several times before. I remember when that decision came down. It is somewhat infrequently raised, particularly where there is not a substantial amount that is presented by way of Social Security income. You know, there are some people that receive $3,000 or $4,000 a month. And oftentimes, I've seen litigants that will say, well, Judge, they're receiving a huge Social Security payment, and then they get this homestead. And so we should be able to collect there. Where you have a situation where a person is receiving $300 or $400 a month, and then maybe they get some homestead, maybe not. That raises some substantial concerns to me as to whether or not that should apply in such cases. This is one of those cases. I'm going to err on the side of finding that the objection is valid in this regard, and I'll release any funds withheld to the to the defendant. All right, so I'll grant the objection to the writ of garnishment in this case. Thank you, counsel.
Thank you, Your Honor.
What happened?
All right, this is case number 22-182638. This is Credit Corp Solutions versus Lamika Baker. The matter is before the court on the filing of petition for installment payments. Also looks like there is objection to a writ of garnishment. The garnishment is as to Carmanos Cancer Treatment Center. The record should reflect in this matter further that a judgment was entered by default in this case. And June, so this is looks like September of 2022. Looks like the judgment in this matter. I don't seem to have a registered action. All right, your appearance, counsel for Credit Corp Solutions, please. Counsel for Credit Corp, I know that Mr. Rusin was here. May have gone to another court. Let me see if I have Miss Baker.
Yes, I'm here.
All right, good morning to you, Ms. Baker. Thank you for your patience in this regard. I was looking for the attorney on the other side of this. I do see that you filed your objections to the writ of garnishment. It looks like this is a garnishment against your employment. Is that correct, ma'am?
Correct.
And the judgment, for some reason, I'm having a problem getting my hands on the second page of the judgment. But it looks like the total judgment against you is about $1,300 or $1,400 or so, correct?
Yeah, that's what they say.
Well, that either is what they say or that's what it is. Did you get a judgment?
No, that's not what it is, Judge.
Yes, it is. I'm looking at it now. It's $1,351.41. That's how much the judgment.
It was for $997, but I'll wait till you get to that. I'll wait till you say what you have to say before I can explain it.
Yeah, well, I'm glad you're giving me a turn to talk about it. The fact of the matter is that you got a judgment in against you. The judgment is for $1,351.41, and the reason for that is because of costs and attorney fees that was added to the judgment. That's why. That's why. Let me see if that's the attorney coming in. I know you have a petition to make partial payments, and that probably makes sense in this case. Looks like Mr. Rusin is back, and let's talk about it in just a moment.
All right, here we go.
Mr. Rusin on the Credit Corp Solutions versus Baker.
Yes, Judge, I'm here and I'm representing the plaintiff as respondent to objection to wage garnishment. I'm also the attorney of record for the case on my bar number 35222.
All right, your name for the record, sir?
Yep, Attorney Richard Rusin.
All right, thank you, Mr. Rusin. All right, and Miss Baker is here, and as I indicated with her, thank you as well for your patience in this regard. I mentioned to her that the judgment, while the complaint started out as she was pointing out at $997, that the judgment was $1,351.41 because of court costs, attorney fees, and things along those lines. She has asked to be able to make partial payments on this judgment, and she wants the garnishment lifted off of her wages.
Yes.
Before I come back to you, Mr. Rusin, I'll turn it over to you, but let me hear from Ms. Baker. Ms. Baker, did I correctly state what's going on here, and anything else you wanted to say to me? Go ahead, ma'am.
All I wanted to state was that on this garnishment that they sent out in September, it was a Value City account. It was two accounts. I paid the first account they told me that Value City, who told me that they combined the accounts together. So I was under the assumption that the account was paid. When they sent the person out to serve me for the paperwork, I've called this company over several times. I've called this company over several times to try to make arrangements. They would never follow up. They would never make arrangements for me. They wanted this to go to court.
All right, Ms. Baker. Mr. Rosen?
Couple of things, Judge. I can't, as a lawyer, I can't address hearsay that I don't have any notice of. And I can tell you, based on the four corners of defendant's filed objection to wage garnishment, Judge, I can tell you that I received $411 from defendant's employer and posted that on her judgment balance December 28th of 2022. The employer indicated that defendant is paid bi-weekly. Now, why do I say that? Because, Judge, I'm only showing a remaining judgment balance today of $411.87. So I don't know how much money as of January the 4th, at the date and time of this hearing, that the employer is withholding pending your order. But I'm going to venture a guess, Judge, that very high probability that by the end of this January, the whole judgment is going to be paid in whole. And then I can just file a satisfaction. So I understand the discussion that you have in these motions for installment payment, but frankly, Judge, I would submit gently, based on the record I'm making, the whole judgment's probably going to be paid by January the 30th, 2023, and I can just file a satisfaction. And for those facts, I ask that you deny the objection today.
Yeah, you're close to paying it off. That's the thing. Well, talk to me, Ms. Baker.
Well, we're not close to paying it off. They just took $411. I would rather pay them the rest of the money than you take it out my paycheck. And that's what I've been trying to do with them. So we can make arrangements and I can get this all paid for you by Friday. I can take it down to 36th District, or I can mail it to your company and have it paid, and you get out my paycheck.
Yeah, I mean, you certainly, you're certainly putting it on the, I mean, this is relatively simple to resolve. The underlying question is whether or not there's a valid objection to the writ of garnishment. And I don't think under these circumstances that there really is, but you're saying, here's what everybody agrees now. Everybody understands that the balance that is owed here is $400 and something. That's what we're talking about. There is some money that has some money been taken from you in January already from your.
It will be on Friday.
Okay. And how much you suspect is going to be taken on Friday?
Another $400.
Yeah, like I said, it's going to pay it off by that time. Then.
How can you determine how you get off of my paycheck? Why can't I pay cash and you get out my paycheck? What I've been trying to do with your company anyway.
Let me help with that. You're making it personal when it works according to rules. There's a judgment against you. When that judgment is against you, then a writ of garnishment can be filed against your wages to collect it in that way, involuntarily. You also, as you have done, can file a petition before the court, but for partial payments. But it looks like to me that that this is going to be paid off. This is going to be paid off by the end of the week, and I don't see how reasonable it is for this court to change anything when it's going to be paid off by the end of the week.
So you agree with the garnishment to stay up for they can get the remainder of their money? That's what you're stating?
Well, the law allows that. It's not a matter of whether I agree with it. The law allows that. Here's what would typically happen. What would typically happen is that I respect the fact that people are wanting to have their autonomy to be able to pay it a different kind of way, particularly when there's a lot involved. You've got a situation now that by the time you got to court, most of this was already paid, and then one more garnishment will satisfy this, and that'll be the end of this case and close the file out. That makes more sense to me under circumstances where the law allows for a garnishment to be issued when there is a judgment standing against you. By the end of the week, this will be paid off, and there will be no further garnishments, and you'll get a satisfaction of judgment showing that this is paid in full.
Well, by the end of the week, it would not be paid off. That would be $800. So it's still another $500 that's due. So I'm not for sure how y'all doing y'all math.
Oh, no. I listen to the creditor. They're the ones that are expecting money. They're saying that as of December the 28th, you only owe $400 and something. So let me hear from Mr. Rusin again.
Yes, Judge, Judge May, please court. I'm needless to say, doing what I do as a plaintiff's attorney, I keep very detailed electronic records. I scan every bit of paper that comes into my office, including paychecks on garnishment. And I'm showing a judgment balance today as an officer of the court of $411.87. Why? Because defendant indicated in her testimony 5 minutes ago that there was $411 taken out of her check. Yeah, that's true. I got that in December and I applied it on her judgment balance. Ergo, I show a remaining judgment balance of $411.87 to satisfy the judgment and hold. On that, I rest.
Yeah, I mean, you got it from the plaintiff that there's once $411 is paid, this is over with.
Okay, but you just stated to me that the judgment was for $1,351.41 minus the $400.
You're right, but if the attorney that represents this company says that all you owe is $411, I'm gonna put my money on that.
Okay. If that's what he
All right.
say.
If you here's what are you gonna do if something different from that happens?
I'm gonna go file another judgment because this company will come, they known to come back and come back to try to take your income taxes and different things like that. I have had a long run in with this company years ago, so I'm sure how they work.
I know you want to fuss, Ms. Baker. I know you want to fuss.
No, I don't want to fuss. I want to stop this judgment and let me pay them. I have bills to pay as well.
Not listening because I'm talking.
Oh, Judge, excuse me. I have to, I just turned on my computer to the right game. Let me say as an officer of the court, I'm sorry, I apologize. I'm showing a remaining judgment balance of $982.26. I have received $411.47. So Judge, I'm going to, as an officer of the court, I'm going to stipulate to defendant paying $60 a month on the remaining balance of this judgment. And I'll leave it to the court as to when the start date is. I apologize for the confusion. My error, I've been dancing back and forth, to use words of Judge Robinson, with several different cases in the 36th District Court today, including Judge Robinson. I apologize, but I'll stipulate to her petition $60 a month. If she wants to start it up 30 days from now, I'll stipulate to that.
All right. Now, the thing is, Ms. Baker, you're right about the number. He goes back, he says there's more. If they had left this hearing today, listen to me. They had left this hearing today saying that you owe $411 and you paid $411, and they came back to say that it was something more, tough luck. It's good that he caught it now. So if you want to pay it at $60 a month, you can do that. It didn't make sense if your one garnishment was going to satisfy the whole thing, as opposed to there being a greater amount. If you want to go with the $60 a month, of course, I'll give you a partial payment, a way of doing that. Now, nobody wants you to be under the garnishment. The only reason we were talking about that was because I thought and he thought you only owe the $411 and you could be done with that by the end of the week, and in this case, be over with. That's what I was getting at.
Yeah, I heard him, but I heard him, but I'm looking at the paperwork and I know how to do math and I work with people every day. So I listen very well.
All right. Apologize that I stipulate the 60 a month.
But that's fine.
All right, very well. So I'll stop I'll sign an order stopping the garnishment. I was hoping that you only owe $411, but.
Yeah,
I was hoping, I was hoping so too.
Just getting old and confused, Judge.
I was hoping so too, but they would have came and garnished my income tax because that's what they're known to do.
Yeah, but if when they come to court and they tell me it's one thing, that kind of locks them in. Okay, so I'm glad it got caught here because it wasn't locked in. Because you come to court and the other side says we got the record shows this and so on and so forth. That's going to be a big hill to climb for them to get over that hill and say, oh, but by the way, she still owes some money. Not when they came to court and told me that you don't, okay?
Okay.
So that's what you're drilling down on this. I'm glad we were able to get to the bottom line with this, and I'll sign the order for the $60 on my payment. I'll set it on the 27th of January and to be paid each month. And as long as you pay that amount, then there won't be any garnishment against your wages, and that'll be paid until you get dissatisfied. All right, and I'm signing the order to release any funds that are withheld will be released to the plaintiff, but no further funds to be withheld. All right, all the best to you, man. Thank you, Counsel.
Thank you. And I have one more on your docket, Judge.
All right, be right with you, sir. Thank you, Ms. Baker.
Your Honor?
Just one moment.
Be quiet. Your Honor, this is.
Ms. Thomas?
Yes, I didn't,
Yeah.
my volume was down low. I didn't hear anything. What was the ruling?
I know you did. That's why I kept shouting at you, trying to get you to turn the volume up and everything. Well, ma'am, I released that garnishment because you're on Social Security, even though there's a case that says that when it deals with homestead taxes, that you get a benefit from that might be something that can be subject to garnishment. I just released the garnishment, ma'am. The money will be given to you, and that garnishment is over with.
Oh, God bless you. Thank you, Your Honor.
All right, God bless you as well, ma'am. You'll get a copy of that document in the mail from me in the next couple of days.
Okay, thank you.
All right, the court now calls case number 2219-4173. This is Discover Bank versus Alexandra Bermudez. The matter is before the court, set on for a pretrial conference in this matter. I did receive its answer, and the claim in this matter is for some $1,846.60. Your appearance for the plaintiff.
Sure, yes. Good morning, Your Honor. Attorney Jason Brainer on behalf of the plaintiff, Discover Bank. My P number is 69653.
All right, thank you, Mr. Brenner. Good morning to you. Ms. Bermudez, if you're on the Zoom, say something to me at this time, please.
Hello, can you hear me okay?
Yes, I can. All right, good morning to you, ma'am. All right, so this case, this is the first time that this case is up before me. It sounds like there was some indication that there was a settlement that was reached in this case, and it was to be paid off in March of 2022. That's what was put in the answer. That's what you put in your answer. Is that correct, Mr. Bermudez?
Yes, correct.
Counsel, what do you know about that, if anything, sir?
So I just have personal knowledge of the answer that she did send in. I did review it, but I don't have any knowledge of the actual settlement itself. So on December the 1st, upon receiving Ms. Bermudez's answer, I submitted that to our client, Discover Bank, for review. And we have yet to hear back from them regarding whether there was any kind of a settlement, what was paid. And so, at this point, I mean, obviously we want to do right by Ms. Bermudez here and make sure that there was no settlement that was agreed to, or maybe that there was. And so that said, I think it'd be appropriate, Your Honor, at this point, just to seek a period of 60 days written discovery, and hopefully during that time frame, we'll be able to clear up this matter, or, figure out the way forward.
So yeah, Mr. Bermudez, it looks like the issue is pending there. There's been a submission requesting information from Discover Bank as to the nature of any agreement that might have been had. Did you get anything in writing? Do you have a written settlement of this in any way?
All I have is the voided form. All I have is the voided form that I received. I used the DocSign to sign that agreement back in 2019, and it should have been there, but when I go back, I cannot see it. So I'm not sure if it was a glitch in the system or what's going on with that, but that's the only form I have as far as assigning. I can't find anything. I've contacted Beyond Finance multiple times and they cannot find anything, but I know there is an agreement somewhere.
All right, and how did you go about moving? You made some payments under the agreement, is that correct, ma'am?
Yes, correct. I have attached all the payment stubs that went to the creditor. I believe they should be in my file.
Oh yeah, I do see your attachments. Counselor, did you receive the attachments allegedly associated with the settlement?
Yes, Your Honor. If you're referencing, it looks like after her scale form that she used to respond to our complaint, there was like a handwritten one-page document kind of outlining what the settlement was. Then after that, there looks like there was a letter from Beyond Finance dated November the 6th, 2019. And then just a list of payments made after that, followed by checks for the different amounts. Is that what you have, Your Honor?
Yeah, that's what I'm talking about. Okay. Wow.
Yes.
A lot of information showing that enough payments were made over a substantial period of time. I guess what you're having to find out is whether or not that's related to this particular account.
Yes, and so that is correct, Your Honor.
All right. Just one second. All right, so yeah, ma'am, I have all of your paperwork here. There's got to be some kind of way relating this to this particular file. So what I'm going to do is I'm going to set the matter over for 30 days and take a review of this. I want to see what Discover comes back with regarding this document of history of payment of some debt. It may not be this debt, but we should know that. You think 30 days is a long enough period to get that information back, Counsel?
You know what, Your Honor, why don't we go 45 just to be safe?
All right, well, let me do this. I'll go ahead and issue my typical discovery order. It'll be a 60-day order. That'll bring me back to court. In March. That's going to be March. Just one moment. Yes. So that's going to bring you back in March. I'll put you March the 7th. 2023. I'm going to set that at 9:30 a.m. and I'll review the matter at that time. And the document that I'm going to issue will give the parties an opportunity to discover information, ask questions, request, admit documents in this matter. It seems that Ms. Bermudez has turned over a lot of documents already, but again, all of that is part of figuring out the direction of this case. So you'll receive a pretrial scheduling order from me in the next few days, and that order will have the new date of March 7th, 2023 at 9:30 a.m. I wish you well. My notations on the file will indicate that
Your Honor.
One second, that the defendant.
I'm so sorry to cut you. Yes.
She believes that the matter has been resolved and that she submitted paperwork towards that end. Ms. Bermudez, go ahead, ma'am.
Yes, I apologize. I wanted to mention that, so my final payment that had paid off the remaining balance was a total of 1,099 and 52 cents. In the summons that I received, there is a statement in from Discover that acknowledges that last payment. I just wanted to mention that. I don't know if it means anything, but I know that they've been receiving the payments. So hopefully somewhere that statement lies.
All right, we'll definitely get to the bottom of it, ma'am, and hopefully we can get some overall acknowledgement that this has been resolved. But it's under this court's authority now, so I'll take another look at all of this on the next action date. All right, thank you very much and good day to you.
And I'll keep working with Beyond Finance.
I didn't hear you then.
I said I'll keep trying to connect with Beyond Finance to see if maybe they have it in their system somewhere.
Real good, real good. All right, so I'll take another look at it in 60 days. All right, good day to you, ma'am. Thank you, Council. Good day.
All right, thank you, Your Honor. Take care.
Yeah. Bye.
Mr. Rosen, you indicated you had another case in front of me, and I don't have.
Yeah, maybe this got adjourned or set. Yeah, I know there's a new judge. Maybe got to her. Can I give the case number, Judge?
Yeah, yeah.
It's 221-96496.
That's Alicia Jones.
That's Alicia Jones Coleman's case, Council.
Do you happen to have her Zoom number? Because again, I didn't get the notes. It got switched over to her.
They got it crossed up a little bit, Mr. Rosen. It's the 534-360-534-0000.
All right. Thanks for that, Judge. See ya.
All right, good day to you. I see an Aisha on this Zoom. Tell me who you are, ma'am, and why you here. Miss Aisha, the only name that I'm seeing is Aisha, so tell me why you're here.
This is me.
Yeah, so why are you in my courtroom today? What case are you here on?
She's
Okay, I
on
can't hear
mute.
you now. You gotta unmute yourself, ma'am. I can't hear you. Ma'am, you have to unmute yourself. I can't hear you. So hit *6 or the microphone on your device. You got it. You're on mute, so unmute. There you go.
Okay, I'm sorry, Judge. This is Aisha Swift. I was here for Modern Finance.
All right, what's the case number, ma'am? You have the case number?
Yes, let me get it. It's in my car. I'm at work. I'm sorry. Hold on. I'm about to get it for you right now. Nope, it was up front sitting on this seat. It was some white paper sitting on.
They're in the back.
Yeah, just spell your last name for me. Give me your last name.
Okay.
Yeah, if you could just spell your last name.
Thank you. Okay, I'm ready, Judge. I'm so sorry. It is 221-965-48.
965-4 what?
48.
All right, got you. Hold on 1 second now.
Alicia Jones.
Okay.
Are you you have to go to a different courtroom, ma'am. That's Judge Alicia Jones Coleman. And so you're gonna have to go out of this Zoom and then dial back into 534. So
Hold on,
36
let me write it down, Judge. Let me write it down, Judge. I'm sorry, I'm at work. I'm trying to do 50 things. I'm so sorry. Okay, I'm ready for the Zoom. I did.
Not a problem. You ready?
Yes, sir.
All right, 360
360.
534
That's it? Just 360-534?
0000.
Okay. I thank you so very much. And
Thank
I'm
you,
so
ma'am.
sorry I was in the wrong spot. I thought this is where I was supposed to be. I hope they forgive me. I'm gonna call right now. Thank you and God bless you and Happy New Year.
So let them know that you were in Judge Coleman's courtroom and you that you were here and you should be okay. All right.
Okay, thank you so much, Judge Coleman. God bless you.
That's a good day.